The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Stacy Sadove, and I'm here with Erica Fitzgerald. On behalf of Littman Krooks, we want to welcome you to our webinar this afternoon. Today we're going to be talking about planning beyond education for your child with special needs. And many of you have probably sat in on our webinars in the past that discuss education needs for your child and what the district and your responsibilities with the district are. Today we want to talk a little bit about what other planning tools are available for your child beyond education. And so a lot of this will focus on financial stability for your child and the risks and pitfalls of leaving for your child if they are on benefits and the risk that can happen if they were to lose their benefits. So before we begin, Erica's going to talk just a little bit about the basics of the education portion of our practice that you may have already heard on our previous webinars, but just a brief overview of what's covered and you know, a little bit more information for you to look for in the future from us.
So there are various laws which are available and protect your child's rights in the area of special education. No Child Left Behind is one you probably have heard of. Section 504 of the Rehabilitation Act, the IDEA, or Individuals with Disabilities Education Act, the ADA, or Title II of the Americans with Disabilities Act, and DASA, which is the Dignity for All Students Act. So if you're in a situation where your child is struggling in school, academically, socially, behaviorally, you may want to consider classifying your child. If your child does not have a full-blown disability that would qualify him or her under IDEA, which we'll talk about in a minute, there's also the possibility of Section 504 of the Rehabilitation Act of 1973, or just Section 504 as it's known. It's a federal law, and this particular law is designed to protect the rights of individuals with disabilities in any program or activity that receives federal financial assistance. This is a civil rights law, and it is put in place to make sure that your children have equal access to the learning and the academic arena comparable to his or her classmates. Even if your child does not have an education-related disability under IDEA, they may still be able to receive accommodations under Section 504. So, for example, if you have a child who has diabetes, or if you have a child who has severe allergies, but they perform fine academically, they still may be entitled to some form of accommodations under Section 504 with an accommodation plan. If your child, however, has more significant educational disabilities, they may be classified under the IDEA. And the IDEA is put in place, it's also a federal law, to ensure that all children with disabilities have available to them a free and appropriate public education, also frequently referred to as a FAPE. And it emphasizes that special education and related services are designed to meet the specific and unique needs of that individual child and prepare them for further education, employment, and independent living. If you want more information about 504s or the IDEA or anything special education related, you can go on to our website, www.special-education_webinar_series. And you'd be able to find additional information regarding the legal rights of students and the responsibilities of your school district.
So like I talked about, you know, our practice area focuses on special education. It also focuses on special needs planning. So what is special needs planning? Special needs planning is taking into account the full picture of your child. So not only their education rights, what they're going to be doing in the future and transition, but also planning for them and planning for you so that you are planning for them if you're no longer there. So today we're going to talk about a few important tools that we recommend to our clients who have children with special needs. And these tools are not just for children with special needs. The Supplemental Needs Trust directly talks to them. But a letter of intent, a will, advanced directives, these documents are documents that have longevity and are for both yourself, your loved ones, and children without disabilities. So these are documents that everyone should have in place because they help plan for your future. So today what we're going to talk about, and we'll talk about them more in detail on the later slides, are a letter of intent, a will, supplemental needs trust, advanced directives, guardianship, and the new ABLE Act. And it should be noted, the ABLE Act is not in existence in New York at this time. We're going to be talking about it slightly hypothetically. It is in legislation now, so it's worth talking about because it most likely will be signed into law in New York, and it should be on your horizon, just to see what is going to happen.
So we'll begin with the letter of intent. It's important to note that a letter of intent is not a legal document, and it can be either a formal document or an informal document. We often recommend when you're writing a letter of intent to do it in as a Word document, because although you want this form of a document to be everlasting and to provide direction after you're gone, after you create it you may want to make changes, and if it's in a Word document form you'll be able to do that. And the idea behind a letter of intent is what you would want for your child if you were no longer there. So a letter of intent would provide parenting tips in a lot of ways, how you would want your child to be raised, the types of decisions you would want to be made for your child if you were no longer there. And it should include specific things that you might not think of initially, like besides if your child has allergies, what those allergies are, what kind of medications they take, but little things like what your child's favorite food is, what foods they don't like or won't tolerate, if your child has sensory issues, what kind of clothes they might like to wear, what type of brand of clothes does not affect that. In my particular case, I have a son with diabetes, so I might include information like what types of pumps does he use and where do I get those pumps, that sort of information. The goal of the letter of intent is to memorialize your particular knowledge of your child's needs so that you can guide any future caregiver, guardians, and trustees in providing the best possible care for your child. You also should include a family history for future reference in case issues like that come up, a daily schedule, specifics on your child's medical information, who their doctors are, what their contact information is, what documents you may have in place in the educational realm. Is there a 504? Is there an IEP? If your child is receiving any benefits, is there a contact person? What benefits they're receiving and when? Any employment history, or your residential environment, what your child's social environment is, any particular friends they may have, any clubs they may belong to, activities they may do. What is your child's religious environment? Do they attend any form of religious services and where? What behavior management do you have in place to assist your child on a daily basis? Also, information that is more practical, are funeral arrangements already established for your child, and other information along those lines.
A lot of our clients ask us, where do you keep this letter of intent? And what we recommend to our clients is have some type of binder or a place where you keep all of your important documents. And you make sure that whomever you're designating as your agent or whoever is going to be in charge when you pass away knows where that documentation is so that they can get it quickly. The one place we do not recommend our clients keep it is a safe deposit box. Now, in the case of a letter of intent, it's not necessarily as bad, but in case of a will, if you don't have access to that safe deposit box or your agent doesn't have access to that safe deposit box, they'll have to get a court order after you pass away to be able to get that information. So you want this information to be handy and accessible, and a lot of times we recommend putting in a fireproof box, either in the basement or someplace in the house where everyone knows where it is, so that in case case something happens, you can easily locate the document. The next document that we're going to talk about is last will and testament. You may have your friends say, oh, I just got this great last will and testament on LegalZoom. Why do we recommend going to an attorney and not using a LegalZoom or a document that you create on your own? New York has very, very specific rules that have to be followed when you're creating a will. Specifically, in terms of the execution or signing of the will must have 2 witnesses, and there's very specific documentation that must occur. A will must be stapled. The original will must be presented when the will is what we call probate or presented to the court after the person passes away. And you don't want to run into the issue where you decided that you wanted to do planning and make a specific designation of your estate, and then that distribution will not be followed because the court will see that the will is not valid. So you want to make sure if you're doing this planning that you're doing it correctly and that you're taking the time to do it correctly so that your wishes can be followed. Because the idea is that you're being proactive and that you're deciding where your estate is going to go in the beginning so that in the end someone else doesn't have to do it and you have the control and authority to be able to decide where your estate goes. Specifically for children with special needs, you want to make sure that your will includes provisions so that if your children are going to inherit from you, your child who has benefits will not lose their government benefits because you leave something to them in a will or outside of a will. So there are 2 different types of assets that someone has. We call them probate and non-probate assets. Probate assets are assets that would fall under your will, and non-probate assets are assets that would fall outside of your will. So something like an IRA or a retirement account or a bank account that has a designation. Anything that has a designation on death, or beneficiary designation, or an asset owned by a trust is considered a non-probate asset and would not pass through your will. So you want to make sure that in addition to making sure that your probate assets are planned for your child with special needs, you also want to make sure that assets that are non-probate assets are going to be planned for. So that means making sure that all of your designations are designated properly so that a child with special needs would not inherit those inadvertently and run into a problem where they lose their benefits.
So as Stacy was talking about, you don't want to have your special needs child lose their benefits. So retitling your retirement accounts may become very important. If you leave a non-probate asset, which means an asset that does not pass with the will, to a child with special needs to take care, you need to make sure that you change the beneficiary designation so that child will not lose their government benefits. Anything, you need to change any form of accounts, IRAs, bank accounts, any non-probate asset, you should retitle in the name of a special needs trust, or that special needs child may very well run into problems obtaining governmental benefits. And so when you're thinking about leaving assets to a special needs child, many clients then, fearing that the child will lose their governmental benefits, won't leave anything to that special needs child. We do not recommend that you completely cut out a special needs child and assume that other siblings or other people will necessarily do the right thing and just provide for the child. You don't want to leave a special needs child who cannot fend for themselves without a way to take care of themselves. So there are risks, but the goal is to preserve the eligibility for special needs based government benefits while supplementing benefits to improve the disabled person's quality of life. So how do you do that? You can do that with a special needs trust or an SNT.
And a lot of our clients come to us and say, well, my child's not on benefits right now, so I don't feel that it's necessary to do this planning. But the reality is that more likely than not, your child with special needs at some point will be on some type of benefits. And so the idea is that you're planning for the future. And so if you do this planning now, you don't have to worry later if your child ends up going on benefits. They're already going to be protected. So like Erica mentioned, one of the vehicles that we use in order to protect assets for a child with special needs is called a Supplemental Needs Trust. We refer to this in the shorthand as an S&T. Assets in an S&T cannot count towards a resource for public benefits. So that means that you can remain SSI Medicaid eligible. It should be noted here that there is a difference between Social Security income, or SSI, and Social Security disability income, or SSD. Social Security disability income does not have as strict assets. The accountability is terms as SSI. So for SSI resources, this is extremely important, and many children, once they turn 18, are eligible for SSI because they no longer are under their parents' resource level. So this is when this comes into play, is usually when you have young adult children who are receiving SSI benefits and need to remain Medicaid eligible, and this is a way to maintain assets for them in addition to the SSI benefits that they're receiving. And there's different types of S&Ts. There's self-settled trusts or first-party trusts. There's third-party trusts, inter vivos versus testamentary trusts, and pooled trusts. And we're going to talk a little bit about each of these different types of trusts in a little more detail.
So we're going to start with discussing the third-party SNT, and this can be done testamentary or inter vivos. And a third-party SNT is a trust that is established by a third person who does not have an obligation to support the individual. And it's usually established by a parent or a grandparent or someone else with no legal duty to support the disabled person. And it's established with their funds, not with the funds of the disabled individual. What's important to note about there are a few important things to note about a third-party SNT. First of all, there's no payback requirement. So that means that if the disabled individual is receiving some form of government benefits, when that individual dies, you do not have to pay back Medicaid for any monies that were spent in support of that disabled individual. There's no right of recovery or lien against that money that was put into the SNT for that person. And there's no age limit for the disabled beneficiary. What does that mean? It means that it can be established for a person of any age. And what's important about SNTs is they can provide for a variety of things, like education, things that the government benefits can't pay for. Travel expenses, so if they want to go on a vacation or they're not able to travel and they want somebody else to travel to see them. Newspaper and magazine subscriptions, personal care services, home care services, non-covered medical expenses, vacations, companions, and pets. Importantly, though, is what can an SNT not pay for? If you have a child who's on SSI, that child's SSI will be reduced if the SNT pays for food or shelter. You can never give the beneficiary of an SNT cash or a cash equivalent. Gift cards may be considered a cash equivalent, and if those items are provided to the beneficiary, their SSI can be reduced.
So Erica, what do we do? And we have a lot of parents who come to us and say, what do we do if we can't give cash or we can't give a gift card? How do we get away with being able to spend money out of S&T? And so, I sometimes recommend to our clients, let's pay the bills out directly. If it's a Verizon bill, let's pay the Verizon bill directly. If it's a, if money is spent on a credit card, then you can pay the American Express bill directly. So, it's a lot. There's a lot of loopholes in order to be able to make sure that the S&T is still be able to pay, but that the SSI remains eligible. And also, Erica, do you mind talking briefly about the difference between an inter vivos and a testamentary trust?
Sure. A testamentary trust is one that is established within the confines of a last will and testament. That's why it's called testamentary trust, as opposed to an inter vivos trust, which is established separate from a last will and testament.
Yeah, so, a lot of our clients will say, well, should I be setting this trust up now or should I be setting it up later? And it really depends on your estate plan and looking at all of your assets in general on, what the best option is for you, but both are valid options in planning for your child.
So when you establish a trust, any form of trust, whether it's a first-party trust or a third-party trust, a lot of consideration has to be given to who the trustee is. There are two options. You can choose either an individual person to be trustee of the trust, or you can choose a corporate option. Usually corporate trustees work with bigger accounts, but there are some local banks, CPAs, or local attorneys who will work with smaller accounts. You just have to choose somebody that you can trust.
So in addition to supplemental needs trust, what are some other documents that can help protect you and help protect your children? So we call these, we group these documents as advanced directives. And so some of, sorry, the allergies today, some of these documents include a power of attorney, a power of attorney gift rider, because in New York there's two different documents that make up the power of attorney. In a lot of states there's only one document for financial decisions, but in New York we have two documents, and the gift rider allows you to make gifts to your agent in excess of $500. This allows for Medicaid planning and a lot of other options that you wouldn't be able to do if you didn't sign this document. So we always recommend that our clients sign both the power of attorney and the gift rider. There's a healthcare proxy, which allows you to make decisions for healthcare decisions. So if you were in the hospital, you were unable to make decisions for yourself, so you can appoint someone to make decisions for you. And a HIPAA release, so if you were in the hospital and your agent needed to have access to your medical records, this document allows your agent to get access to those medical records. There's also a living will, or you may have heard when you go into the hospital, sometimes it's called a DNR, do not resuscitate. And this allows you to make decisions with regard to end of life. And you can show your intent and what you would like your agent to pursue in terms of end of life decisions. Another document that we recommend that clients look into is a disposition of remains. And this states where your body would go at the time that you pass away. You can also discuss funeral arrangements and if you've entered into a pre-funded burial contract. This can also provide information of where a deed is in terms of a burial plot, or if there's a certain way in which you wish your body would be disposed, for example, cremation. All of these advanced directives can be done for yourself, or if appropriate, they can be done for your child with special needs. It depends on the capacity of your child. These documents require a certain level of capacity, and so talking with your attorney, you can determine whether or not they have the ability to sign these documents on their own. In New York State, once your child turns 18, they have the ability to do whatever they want. They are considered an adult. You no longer are considered their parent in the eyes of the law. So in order to continue to make decisions, either they have to have these documents in place, or you need to pursue a guardianship. And this can be a scary proposition at the time that a child is transitioning. Your child may be in school until 21. They may not graduate at age 18. And if that's the case, you want to make sure that you still have access to their education records, that you're still able to speak with the school about the decisions that they're making in school. So all of these documents are extremely important. And if you do have a child with special needs, you want to start thinking about either signing these documents or looking into a guardianship around age 17. So what is a guardianship? As I said before, a person turns 18 when they are considered emancipated. And a guardian has the right and responsibility to make legal decisions and help a person manage their personal and or financial affairs. So you can't appoint a guardian by a will. A will must be appointed. A will can recommend a guardian, but a guardian has to be appointed by the court. The guardianship lasts until it's revoked by a court. And there are many different duties of a guardian. A guardian can deal with financial duties, a guardian can deal with healthcare duties, and basically you take the role of helping the individual help themselves, and you make all decisions for them. You can also appoint a standby guardian, and we recommend that you do appoint a standby guardian. You don't want to run into this issue where you only appoint you or a spouse, and then what happens? So we always recommend that you appoint a standby guardian. It should be noted that if a standby guardian is appointed, that standby guardian does not automatically become guardian if the guardian needs to step down. The standby guardian needs to go back to court to be elevated to that of guardian. So is a guardianship necessary? Again, a guardianship is restrictive. It's not necessary in every case. There are many children with special needs that have the ability to make decisions on their own and just need a little bit of help. And in that case, advanced directives are more than enough for them. But in many cases, they're not enough. And so a person who has not been able to execute advanced directives may need a guardian. And in guardianship, you want it to be in the least restrictive means possible. In New York, there are two different types of guardianships. There's Article 17A, which is for developmentally disabled persons, and there's Article 81. And both guardianships are, very different. And Article 17A is a little more broad. It is required that you have developmental disability, and the developmental disability must occur before the age of 22. It can include disabilities such as cerebral palsy, a neurological impairment, autism, or intellectual disability. It should be noted that this is an overall guardianship, so there's no tailoring this guardianship. So if you're, for example, ward needs, only specific help with getting dressed, but doesn't need help with other things, you can't pick and choose what powers the guardian has. In this case, they're generally broad guardianship powers. So an Article 17A guardianship is not for everyone. And that's why there's Article 81 guardianships. These are typically used for adults, and a lot of times in our elder law side of our practice, we use this for incapacitated persons or adults, but it can all be used for children with special needs. And it's stated under health hygiene law, and it allows the court to appoint a guardian to manage the personal and/or financial affairs of a person who can't manage their needs for themselves. And in this case, an Article 81 is much more tailored, and it allows you to pick and choose the powers that are necessary for the guardianship. So a lot of times with kids who are a little more high functioning and don't need help with everything, we can do an Article 81 guardianship to use the least restrictive means possible of guardianship.
And now we're going to get back to talking a little bit more about the different types of SNTs that are available for your special needs child or any individual who may need one. So a self-settled SNT is also known as a first-party SNT. And it's first-party because this particular SNT is established with the disabled person's own money. And this money and these assets can come, they can be the proceeds of a personal injury lawsuit, a malpractice action, or other court action where they have received a large sum of money. It can also, a first-party SNT can also be established with inheritance money or a gift which was given prior to the creation of the first-party trust. So who can establish a first-party SNT? Well, it can be established by a parent, a guardian, or a grandparent. Any pending Medicare or Medicaid liens must be paid prior to the funding of first-party SNT. And interesting, in comparison to a third-party SNT, which can be established when the disabled person is any age, a first-party SNT must be established prior to the disabled person turning 65 years of age. Also, in contrast to the third-party SNT, a first-party SNT has to include a payback provision. So that means that upon the death of the disabled individual who has established the first-party SNT, Medicaid must be repaid for all money that they have expended taking care or providing for the disabled individual. You must notify HRA or DSS regarding the establishment of the trust, that there will be accountings to expect, and there are annual accountings. Oftentimes, you must report to the court because it's based on a court settlement. And now another form of trust which people like to take advantage of frequently is a pooled trust. Typically, a pooled trust is funded with a beneficiary's assets, but it could also be funded with a third party's assets as well. There are benefits to a pooled trust versus a traditional first-party trust. A pooled trust is managed by a not-for-profit organization. For example, UJA or the Teresa Foundation are organizations which have pooled trusts for disabled, and they manage pooled trusts for disabled individuals. And it's called pooled because the assets of all the people who belong to the pooled trust are pooled together, and the nonprofit agency manages sub-accounts for each individual beneficiary. If the trust is funded with the beneficiary's assets, the funds stay with the agency upon that individual's death. If the pooled trust is funded with a third party's assets, the agency is entitled to keep a portion of those funds. The benefits is it's smaller, and if someone leaves you a small amount of money and it's too much money, for example, let's say a disabled person inherits $10,000 and they're receiving government benefits. It may be too difficult for that individual to spend down enough money to actually keep their government benefits and have them unaffected, but they need to do something with the money. So you can establish a pooled trust and put the money into the pooled trust so that the individual maintains their eligibility for governmental benefits and still have this influx of money. There are different kinds of trust, pooled trusts in New York. As I mentioned, UJA is one, the Teresa Foundation is another, and NYSARC is yet another example of different pooled trusts which exist in New York.
So briefly towards the end of this presentation, we want to talk about the ABLE Act. And again, as I stated before, the ABLE Act was signed into federal law on December 19, 2014, but it's not yet enacted in New York State. It's currently pending legislation. So we don't know if it's going to be signed in New York. We're assuming that some will be. An ABLE account is limited on how you can account. So many people have been talking about whether an ABLE account will be worthwhile in comparison to a supplemental needs trust. And right now we just don't know enough about them, but from what we have seen that has come out, we're still recommending in many cases a special needs trust because they are very limited in how they act, and while they are beneficial, you don't have as much flexibility as you do with the special needs trust. So an ABLE account, you can only put in $14,000 per year from all sources, and that can only go to the one ABLE account. ABLE accounts have a payback provision, so similar to a first-party trust, it requires reimbursement to the state when the beneficiary dies for all the money that the state has paid, including for third-party contributions. So that means that anyone who submits money to this account, that money is going to be required to be paid back. The benefits were paid back for the beneficiary during their lifetime. Third-party is the payback provision. So limitations on ABLE accounts. You can't use if the disability onset was after age 26. So you have to make sure that the disability occurred prior to age 26. And if the amount in the ABLE account exceeds $100,000, the beneficiary will lose their SSI. So there's a cap on how much you can put in an ABLE account. And you, again, cannot fund it greater than $14,000 per year. And again, there's a payback provision, which is unlike a third-party S&T. If you were funding that with, the grandparents are funding it, the parent is funding it, those would not have a payback provision if you put it in an S&T. So when should you consider using an ABLE account? If there's a small inheritance, and wasn't correctly activated for third-party S&T, full trust. It gives you a little more control rather than having a nonprofit controlling the money. You are able to control the money. Again, if a under $14,000 litigation settlement came in, this is a good way to be able to keep that money so that the beneficiary is still eligible for benefits, but it gives you a little more flexibility than if you were going to put it into a first-party pooled trust. The beneficiary has unspent SSI or SSD earnings that are going to push them over resources. Again, this may be an option that you want to use because it's a small amount of money. You're anticipating that the money is going to be used during the beneficiary's lifetime, so it may not matter that there's a payback provision because you're anticipating that all the money will be used up once the beneficiary passes away, or at least and that's our basic overview of special. Oh, okay. Just want to talk just quickly a little bit more. In terms of a payback provision, we talked a little bit about what is a payback provision. You may have a question about what is a payback provision. And a payback provision, again, just means that you have to pay back to the state anything that was put in. So that's basically our presentation for today. And you know, you may have a lot of questions. It's a lot of information, and it's a general, broad overview of special needs planning for individuals. And so, you know, we want to make sure that you have that. In Article 17A guardianship, he created to an Article 81 guardianship if the special needs child acquires additional, converted, excuse me, if the child acquires additional skills and needs less guardianship oversight. So the answer is no. At the time that if a guardianship needed to be changed, what you would have to do is the Article 17A guardianship would no longer be needed. You'd have to ask the court to revoke it, and if a new guardianship was needed where certain powers were needed, then you would then go to an Article 81. So when you're making that original assessment on whether an Article 81 or an Article 17A guardianship is appropriate, you would want to make sure that you're carefully considering whether or not the child's disability is going to change, and then go from there. Forward to hearing your comments and concerns and topics that you're interested in. So feel free to reach out to us via our website, and we look forward to speaking with you soon.
Thank you and have a nice day.